Good morning, students. Welcome to the online class of School of Open Learning. Myself, Guneet Kaur, and I'll be taking over company law. And as in the previous class, we talked about Memorandum of Association. So first of all, we will complete the chapter number 4 of Memorandum of Association, as we are just left with one last topic, which is Doctrine of Ultra Vires, and post that we will start the next chapter, that is chapter number 5, Articles of Association. So students, as always, we will keep the last 10 to 15 minutes for your queries, for your doubts, or anything that you want me to repeat. So let's start with the last topic of Memorandum of Association, which is Doctrine of Ultra Vires. So students, the term ultra vires means anything that is beyond the power of the company, anything which is against the rules and regulations of the company, anything which is against the objectives of the company, or I should say anything that is contrary to the scope or the activity of the company. So ultra vires means beyond the powers of the company. Students, we know that Memorandum of Association is the constitution or charter of the company. It defines the objectives and powers of the company. So anything which is contrary, or contrary means anything which is opposite, or anything which is against the scope or activity or the objectives laid down in the Memorandum of Association, is ultra vires the company. So beyond the scope. So students, as you can see, acts ultra vires the company can neither be legalized nor ratified even with the unanimous consent of all the members of the company. See students, if your company objective is that you want to that you will be conducting business in say power sector, okay? So now you are doing any business activity that relates to the water sector. So this act of doing business in any other sectors ultra vires the company because it is beyond the objectives or beyond the scope of the MOA. So anything which is contrary can never be legalized nor ratified. So ratified student means valid. ऐसा नहीं है कि अगर आप कुछ भी न्यू ऑल्ट्रेशन करो या आप कुछ भी न्यू सेक्टर में जाओ विच इज अगेंस्ट योर कंपनी, विच इज अगेंस्ट द स्कोप ऑफ द एक्टिविटी ऑफ द कंपनी, तो ऐसा नहीं है कि बाद में उसको वैलिड माना जाएगा, रैटिफाई करा जाएगा, ऐसा नहीं होगा. इवन इफ देयर इज कंसेंट ऑफ ऑल द मेंबर्स, अगर सारे के सारे मेंबर्स अग्री भी कर जाते हैं, देन ऑल्सो these acts which are ultra vires, which are against the scope of the company, they can never be considered as valid acts. Okay. So rationale of the doctrine. The doctrine of ultra vires is primarily developed to protect the interest of the investors and the creditors. So students, basically ultra vires क्यों आया इसका doctrine? Because जो इन्वेस्टर्स हैं जिनका मनी इन्वेस्टेड है बिजनेस में, दे शुड नो दैट वेयर देयर मनी इज गोइंग. दे शुड नो बिफोर इवन स्टार्टिंग कैसे होती है. वी डेवलप, we create MOA, we write down all the objectives and scope of the business, then we give to our investors, we give it to our subscribers so that they should know where the money will be invested because it is their money. So if there's anything the company or anything that directors of the company do which is against the scope of the company, against the objectives of the company's ultra wise, because this thing we haven't told about, this thing we haven't told our investors, we haven't told our creditors. So basically the idea is to protect their interests so that they should have the right information about the company, about the activities of the company. Now, with this doctrine of ultra vires, the investors and the creditors are assured. They have faith they have a trust in the company that their money, their investment will not be directed for any other activity, because they know that there is a doctrine of ultra vires which allows the company to do only those acts that are within their scope. Let's now discuss what are the effects of ultra wires transactions. अगर ultra wires transaction होती है, then what are their effects? Then what steps can be taken? Ultra wires transaction means anything that is beyond the scope, or anything that is against the scope or objectives of the company. So number one is injunction. So students, injunction means you can go to the court, you can you can put a stay, or you can order from the court that any member of the company can bring injunction against the company to restrain it from doing ultra wires act. So if you see that your company is doing ultra vires acts, then you, all the members, any member can go to the court and bring an order against the company. They have the power to do so. So injunction means you can appeal to the court, bring an order against the company. Liability of directors towards the company. The directors of the company are personally liable to make good those funds of the company which they have used for ultra wires. So basically, if anything, any ultra vires acts are done, then it is the liability of the directors to make good, to compensate the members, to compensate the investors and creditors of the company. So liability goes to the directors. उनकी liability है to make sure कि अगर कोई भी acts होते हैं ultra wires purpose के लिए, so they have to compensate for it. So again, liability of directors towards the third party. Directors are the agents of the company. It is their duty to conduct the affairs of the company within the powers of the company as laid down in the memorandum, where the directors represent the third party that the contract entered into by them on behalf of the company is within the powers of the company, while in reality the company have no such powers. So students, basically जो हमारे directors होते हैं वो एजेंट्स होते हैं कंपनी के अफेयर्स, कंपनी के डिसीजंस आर ऑल टेकन बाय डायरेक्टर्स, सो दे आर लायबल इवन टू द थर्ड पार्टी. ऐसा नहीं है कि कंपनी एंड थर्ड पार्टी के बीच में ट्रांजैक्शन है सो डायरेक्टर्स विल नॉट बी इन्वॉल्व, ऐसा नहीं है, बिकॉज कंपनी की ट्रांजैक्शंस आर डन by the directors, they are the agents, so they are also liable to the third party for any losses. Next effect is students, contract void. A contract which is ultra vires, the company will be void and of no effect whatsoever. So अगर कोई भी कॉन्ट्रैक्ट कंपनी ने अल्ट्रा वायर्स के करे, then those contracts will be void. ठीक है, they will not be termed as legal contracts, and an ultra vires contract being void ab initio cannot become intra vires by any reason of a stipple, so they are void contracts. So any contract which is ultra vires is void contract, void ab initio. Ultra vires acquisition of property. When money of a company is spent ultra-wise in acquiring a property, the right of the company over that property would be secure. This is because the property represents corporate capital, though acquired wrongly. However, where the payment for an ultra-wise acquired property asset has not been made, the vendor can obtain a tracing order to recover the property from the hands of the company. A company cannot be allowed to benefit from such transaction at the cost of the other party. So students, अगर आपने एक transaction करी in which there is acquisition of property, so it is an ultra wire transaction. You are not supposed to acquire a property, but you have done that. Now, in that case, special case, the company has the right over the property because it represents corporate capital. You have acquired that property out of the capital of the company. So though it has been acquired wrongly, but it is the property, it will be considered as property of the company. Now if there is any pending payment, you have not made full payment to the vendor for the property, then in that case the vendor has the right to acquire back its property. Similarly, ultra-wise borrowings. A bank or other person lending to company for purpose ultra vires cannot recover the money under the loan agreement, but nothing prevents the company from repaying that money. So a bank if a bank has lent money, अब एक बैंक ने कंपनी को money lend करा है for purposes ultra vires the memorandum for any transaction that is against the memorandum, so bank has no right to recover the money under the loan agreement, but company can repay that money. Sorry, next is ultra vires lending. If the money has been lent by the company and the lending is ultra vires, if the money has been lent by the company and the lending is ultra vires, the contract would be void. So, if the money has been lent by the company, if you have lent the money of your company and the purpose for lending money is against ultra vires against the scope of the activity of the company, then the contract would be void. So students basically in all such cases, and the last is ultra vires torts. In order to make the company liable for the civil wrongs of its employees, it is to be provided that the tort was committed in the course of an activity which falls within the purview of the company's memorandum. The tort was committed by the employee in the course of his employment. So ultra vires torts, student torts means civil wrong, anything that is not legal. In order to make the company liable for the civil wrong if its employees, ये prove होना चाहिए that that civil wrong was committed in the course of an activity which falls within the purview of the company's memorandum. The civil wrong was committed by the employee in the course of his employment. So, if you want to make your company liable for the illegal activities of illegal actions of your employees, so you have to make sure that आपकी company तभी liable consider होगी जब ये जो acts हैं employees ने अपनी employment में ही करे हों. ठीक है, first says that these acts was committed in the course of an activity and these acts should be under the purview of company's memorandum. So students, this was all about memorandum of association, doctrine of ultra vires. So we have completed this chapter. Now we will start the next chapter, that is articles of association. So our next chapter is chapter number 5, articles of association. Like I told you in the last class that memorandum of association is the main document. It is the charter or constitution of the company, whereas articles of association is a subsidiary document. It is not the fundamental document. It is a subsidiary document of the company that governs the rules and regulations of the internal management. जहाँ पर स्टूडेंट्स हमें पता है कि जो भी कंपनी के ऑब्जेक्टिव्स हैं, पर्पस हैं, all these things are defined in the memorandum of association, but the rules and the regulations, how much dividend will be paid, uh, anything related to audit of the company, and so many other things related to the articles of association. So let's start this chapter. Of association is an important document of the company. It contains rules, regulations, and bylaws for the internal administration. So basically, जो भी company के rules and regulations हैं, internal management के, internal administration के, everything is written in the articles of association. So this document governs the internal management, business, or administration of the company. So articles lay down the rules and regulations to manage its affairs. So students, जहाँ पर memorandum of association is for the objectives and purpose of the business, whereas articles defines the rules and regulations to manage the activities of the internal management. अब now let's see कि relationship क्या है. What is the relationship between the memorandum and articles? फर्स्ट इज मेमोरेंडम इज द चार्टर ऑफ द कंपनी. जो भी मेमोरेंडम है वो चार्टर है, दैट इज द कॉन्स्टिट्यूशन ऑफ द कंपनी. ये इट डिस्क्राइब्स द कॉन्स्टिट्यूशन ऑफ द कंपनी एंड कंपनी की स्कोप, एक्टिविटीज, पावर्स, ये सब कुछ होता है हमारे मेमोरेंडम में. whereas article lays down the rules and regulations to manage its affairs. So जितने भी rules and regulations हैं वो सारे हमारे articles of association में mention है. Next is articles of company are subordinate to the provision of memorandum. Articles of company है subordinate. Subordinate means they are lower in the rank. Higher क्या है memorandum. So memorandum से एक rank नीचे, एक rank lower is articles of the company. So memorandum contains the area beyond which company cannot go within that area. The shareholders may make such regulations for their internal working as they think fit. So students, basically memorandum is the highest authority, highest provisions. Anything which is written in the memorandum is final. Nobody can go beyond that. No act of the company can surpass the memorandum of association. Next is articles can be used to explain the objects laid down the memorandum but never to extend them. So हम जो हमारे जो articles हैं उसको article of association को हम sometimes use करते हैं to explain some definitions, to explain some objectives, whereas in memorandum we just write what are our objectives. We don't put much of the explanation. So basically students, this was the relationship between the two. Memorandum needs to be created very carefully, very detailed, whereas article of association need not be constructed too meticulously, means there is not much great detail, not much technicalities is required to prepare article of association. It's much more simple and straightforward. Now let's see what are the contents of article. The article of association of company usually deal with the following matters. अब हम देखते हैं कि जो हमारा article of association है इसमें क्या क्या चीजें cover होती हैं. What does all it includes? Number one is important terms and phrases. कोई भी important term है, कोई भी phrase है, वो आपको मिल जाएगा article of association में. Share capital and rights attached to different classes of shares, वो भी आपको मिल जाएगा. Next is procedure as to making of calls and forfeiture of share. Appointment of managerial person, आप कौन से directors appoint कर रहे हो, कोई rotation है, what are their powers, duties, everything. Then there are rules related to meetings, share certificate, common sale, dividend, accounts and audit, everything. So for all these things, there are rules written in the articles of association. So basically students, the article of association includes rules and regulations of the company specifically for the administration of the internal management. Next topic is binding effects of memorandum and articles. So article bind the company to its members, the members to the company, and members to each other. They constitute a contract between a company and its members in respect of their rights and liabilities as members. A member may sue the company just as the company may sue the members to enforce and restrain any breach of the article. So students, a very important topic, that is binding effects of memorandum and articles. So binding effects means now you have an article of association in your company. So it has been signed by the members. So what does it mean? That any acts of the company are binding upon the members and any act of the members are binding upon the company and any acts of one member are binding upon the act of another member. So basically, when there is an article of association, when there is a memorandum of association which is signed by the members and the company and everybody, then there is a relationship between company and the member, member and member, member and the company. So both these parties, the company and the member are binding upon each other. They are equally liable for the acts of other. They are equally responsible. They share a relationship. So अगर आर्टिकल ऑफ एसोसिएशन में आपने साइन करा है, देन आप कंपनी के जो भी एक्टिविटीज करते हो उसके लिए आर्टिकल ऑफ एसोसिएशन के अकॉर्डिंग आप बाउंड है, कंपनी बाउंडेड है अपने मेंबर्स के ऊपर. सिमिलरली मेंबर्स आर बाउंडेड बाय द कंपनी, मेंबर्स आर बाउंडेड बाय ईच अदर. So first is binding upon company. So let's understand this. Company is bound to the members to observe and follow the articles. In case the company commits a breach of its articles, members can restrain the company from doing so by bringing an injunction, means order, against the company. Members may sue to restrain a company from doing any ultra vires or illegal acts or from acting on a resolution obtained by fraud or which is inconsistent with articles. So students, अगर कभी भी आप देखो कि कंपनी में कोई भी आप कोई भी अल्ट्रा वायर्स एक्ट हो रहे हैं which is against the articles, against the provisions of the company, so members can go to the court. Members can go to the court. They can bring an injunction. They can bring an order against the company. They can hold company liable for the acts, and they can restrain the company from doing so. So binding upon a company means that company is bound to the members. It means members can observe and members can look over the acts of the company, and they have the power to bring an injunction against the company if they see that there are any illegal acts or any ultra vires acts are done by the company. So this is binding upon company. So students, there's one case that is Wood versus Odessa Waterworks Company. So this case says that the articles of the Odessa Waterworks Company provided that the directors, with the sanction of the company at general meeting, declare a dividend to be paid to the members. So this company, the company's article of association provided that the directors, with the sanction of the company at general meeting, declare a dividend to be paid to the members. So कंपनी के आर्टिकल ऑफ एसोसिएशन में लिखा गया दैट जो डायरेक्टर्स हैं दे विल पे डिविडेंड टू द members of the company. So when nothing is mentioned about how dividend will be paid, it is assumed that dividend will be paid in the cash. Now what does the directors do? That instead of giving it in the cash, they have declared the dividend. They have passed a resolution to give them dividend in the form of debenture bonds. Now, one of the members, in an action by a member to restrain the directors from acting on the resolution, so one of the members of the company went to the court, and he said that this provision, this act of giving dividend in the form of debenture bonds is not right, because in the article of association it was said that it will be paid to the members in the form of cash. Now the court held that the question is whether that which is proposed to be done in the present case is in accordance with the article of association of the company. Now, in the article of association, it was said that directors will be paid in cash. Now, the directors have paid it in the form of debenture bonds. Prima facie, that means to be paid in cash. Okay? It was supposed to be paid in cash, but directors have paid in the form of debenture bonds. So the debenture bonds proposed to be issued are not a payment in cash. Accordingly, the court held that the directors were restrained from acting on the resolution. So court ने भी यही बोला कि directors cannot do such an act if articles में अगर लिखा है कि आपको cash में payment करना है, जब आपने journal meeting में यही सब members से agree हुआ, then directors don't have any power to change it. So it was held in the court that directors are restrained from acting on the resolution. Second is binding upon members. Students, जैसे company liable है अपने acts के लिए, similarly members are also liable for their act. Article of association is a contract of the most sacred character between the company and each member, binding the members to the company under a statutory covenant. Covenant means agreement. So जैसे कि company liable होगी अगर कोई भी acts company करती है against the provisions of the article of association, just like that if anything done by the members of the company, then also they will be held liable. So all money payable by any member to the company under the MOA shall be a debt due from him to the company. So all money payable by any member, अगर कोई member money pay कर रहा है to the company under the MOA shall be a debt due from him to the company. Next is binding between members. Student, just like binding upon company था, binding upon members tha. Now this is binding between members. So there is a relationship between the members as well. The contractual force given to the article is limited to the matters arising out of the company's relationship of the members as members and does not extend beyond the company relationship. It means the articles constitute a contract between each member and the company. So binding between members, that members are also have a relationship with each other. They are also binding upon between members. There is also a binding between them. The article do not regulate their rights. Enter such rights can only be enforced by or against a member through the company. So students, ऐसा नहीं हो सकता that members have a conflict between each other, that directors or जो company के members हैं they have any conflict and then they couldn't go to the court. This is not possible. Generally क्या होता है कि members और company के बीच में conflict possible है and then they can appeal to the court, but they can not go to the court when there's any conflict arising between each other. Next is no binding upon the outsiders. The memorandum and articles do not constitute a contract between the company and the third party. The students MOA and AOA, they are only binding upon the company and the members and between the members, but they are not binding upon the third party. कोई भी आप third party के साथ transaction करोगे तो in that case आप ये नहीं बोल सकते that you are going against the provisions of article of association because वो third party है, it is a separate company and they have their own rights. Next topic is alteration of articles. So students, just like हमने memorandum of association में पढ़ा that we can alter the name clause, we can alter the object clause, we can alter the situation clause and so on. So just like that, हम article of association को भी क्या alter कर सकते हैं? Yes, we can. The company can alter its article of association by passing a special resolution. So one thing I want to clear that what is the difference between the special resolution and ordinary resolution? So students, an ordinary resolution can be passed with some of the majority. ऐसा नहीं है कि अगर आपका कोई resolution है, ordinary resolution means that you are bringing any change, you are bringing any new resolution. So उसके लिए आपको थोड़ी सी majority चाहिए to pass that. But special resolution means that for that you need 3/4 of the majority. So special resolution को हम special क्यों कहते हैं? Because it requires 3/4 of the majority to pass that, to bring it into effect. So an alteration, you can do the article of association alter by passing a special resolution, which means you need 3/4 majority of the members. Now, however, there are certain limitations or restrictions on the powers of the company to alter its article of association. Now, company can alter or company can limit, company can alter the article of association, but uske liye there are certain limitations, there are certain restrictions. So let's understand what are these restrictions. Number one, articles can be altered only by a special resolution. So students, you cannot alter the article by passing an ordinary resolution. अगर आपको articles of association को alter करना है, then you have to do it by passing a special resolution. Second point says alteration can neither be beyond the provisions of the companies or nor the memorandum. Obviously, students, when memorandum of association is the highest document or the charter of the company. So alteration should not be anything beyond that प्रोविजन. कुछ भी ऐसा नहीं होना चाहिए जो आपके एमओए और एओए के स्कोप से ही बाहर हो. इट शुड बी विद इन दैट, देन ओनली आपकी ऑल्ट्रेशन पॉसिबल है. नेक्स्ट इज alteration of articles seeking to take away the company's power to alter its article would be void. अगर आप alteration कर रहे हो and alteration में what you are doing is कि आप कंपनी के पावर को ही ले रहे हो, then such kind of alteration is not valid, it is void. Fourth, alteration seeking to impose an additional liability of on a member. अगर आप कंपनी के आर्टिकल ऑफ एसोसिएशन को ऑल्टर कर रहे हो, बाय किस पर्पस से कर रहे हो? बिकॉज आप चाहते हो कि आप एक एडिशनल लाइबिलिटी ऐड कर दो मेंबर के लिए, देन इट विल नॉट बी कंसिडर्ड एज वैलिड अनलेस जो मेंबर है वो राइटिंग में अग्री करे दैट आई एक्सेप्ट एन एडिशनल लाइबिलिटी. Next is alteration should not be illegal or against public policy. Because obviously if you are doing any alteration, so ऐसा नहीं then ऐसा नहीं होना चाहिए कि आप एक illegal alteration कर रहे हो, doing anything that is against the public policy. Next is the power to alter the article must be exercised by the shareholders in good faith for the benefit of the company. So students, if you are altering the article of association, then it should be in good faith. Next is the power conferred on the company under section 14 of the act to alter the articles by special resolution is very wide, but the power shall not be abused by the majority of the shareholders to deprive the minority of their rights or to oppress the minority. So student, ऐसा नहीं होना चाहिए that आप alter कर रहे हो article of association को, so for that आप एक special resolution करोगे then only it's possible. So ऐसा नहीं होना चाहिए that you are doing it to deprive the minority of their rights or to oppress the minority. ऐसा नहीं होना चाहिए कि सारे शेयर होल्डर्स they all together agree कि हम लोग इसको alter करेंगे, not because they want to do it, just because वो they want कि वो oppress करे जो minority है, उनका decision नहीं होना चाहिए. They are just altering the article so that they want to show their power. So ऐसा नहीं होना चाहिए. Next is certain provisions of the articles cannot be altered except with the prior approval of the tribunal. So student, ऐसा नहीं है that you can always pass a special resolution and alter the article. So there are certain provisions for that you need approval of the prior approval of the tribunal. For example, if you're converting a public company into private company, so for that, before passing a special resolution, you need a prior approval of the tribunal. Next is a company can alter its articles even if it causes a breach of agreement with the outsider. So students, this is also possible. Again, if you're dealing with some other company and there is a breach of agreement with the third party, now it doesn't basically आपको वो रोकता नहीं है to that you cannot alter your article of association even if you have a breach of agreement with any outsider. That is a separate matter, and altering your article is your personal thing. This is your company, this relates to your company, so that you can do it even if you have a breach of agreement with the outsider. So students, this is all about the limitations or restrictions regarding alteration of article. So I think it is clear to you all. Next topic is distinction between MOA and AOA. This we have already discussed, so let's do it very quickly. What is the difference between the MOA and AOA? First difference is meaning. MOA is the head. It is the charter of the company. It is the fundamental document, whereas AOA includes the rules and regulations that govern the internal management. So MOA is the fundamental document containing the objectives and the powers, whereas AOA includes the rules and regulations of the company and the management. Now, third point is alteration. We have studied in the last class that there are different clauses in the memorandum that needs to be altered. जैसे अगर आपको name clause को alter करना है, then there are provisions for that. Situation clause को, then there are provisions for that. So it is not easy because there are different clauses in the memorandum of association, whereas in article of association, members can easily alter the article of association by passing a special resolution, provided the conditions are satisfied. Next, MOA, Memorandum of Association, cannot include any clause contrary to the provisions of the Companies Act. So Companies Act के against कोई भी provision नहीं होना चाहिए MOA में, whereas Article of Association जो है वो subsidiary है दोनों से, MOA से and Companies Act से. तो students higher क्या हो गया Companies Act, उसके अंडर क्या है MOA, and MOA के अंडर क्या है आर्टिकल ऑफ एसोसिएशन. सो आर्टिकल ऑफ एसोसिएशन में कुछ भी ऐसा नहीं होना चाहिए which is contrary to the provisions of both MOA and Companies Act. Last point is ratification. Acts done by a company beyond the scope of memorandum are absolutely void. अगर आप कोई भी acts करते हो, you are doing any transaction that is against the scope of memorandum of association, they are completely void. They cannot be valid, they cannot be ratified. But अगर आप आर्टिकल ऑफ एसोसिएशन में कोई भी एक्ट करते हो विच इज बियॉन्ड, अगर आप कोई भी एक्ट करते हो विच इज बियॉन्ड द स्कोप ऑफ आर्टिकल ऑफ एसोसिएशन, सो दे आर इरेगुलर बट दे कैन नॉट बी कॉल्ड एज वॉइड. वो जो भी ट्रांजेक्शन आप करते हो विच आर बियॉन्ड द स्कोप ऑफ आर्टिकल ऑफ एसोसिएशन, दे कैन बी सब्सिक्वेंटली वैलिड. अगर शेयर होल्डर्स अग्री करते हैं तो वो एक्ट वैलिड भी हो सकते हैं, बट MOA के अगेंस्ट आप कोई भी एक्ट करते हो that then they can never be valid. They are absolutely void. This is all about the difference between memorandum of association and article of association. So our next topic is constructive notice of the memorandum and articles. So I'll be taking 5 more minutes, and probably this is the last topic for the day, and we will continue anything that is left. I think only one topic will be left that we can take up in the next class. So 5 more minutes, and then last 15 minutes will be for your doubts and queries or anything that you want me to repeat again. So our topic is last topic for today is constructive notice of the memorandum and articles. So students, this is known as the doctrine of constructive notice. So doctrine of constructive notice is that a person dealing with the company is deemed to know the contents of the company's memorandum of association and articles of association. So students, doctrine of constructive notice कहता है कि अगर कोई भी person company के साथ deal कर रहा है, so that person must know about the contents of the company's MOA and DOA. So ये जो हमारा constructive notice का doctrine है, वो कहता है कि अगर whereby any person dealing the company, then that person must know about the contents of the company. The memorandum and article of association of every company are registered with the ROC, registrar of the companies. So students, we know that MOA and AOA, they both are the public documents. ये हम किसके पास registered होते हैं? With the registrar of the companies. So it is therefore the duty of person dealing with the company to inspect its public documents and make sure that his contract is in conformity with their provisions. अगर कोई भी person deal कर रहा है company के साथ, so वो person की duty है to make sure that that he is aware, he has full information about the article of association and memorandum of association. Another effect of this rule of this doctrine of constructive notice is that a person dealing with the company is taken not only to have read the documents but also to have understood them according to their proper meaning. So students, doctrine of constructive notice कहता है कि अगर कोई भी person company के साथ deal कर रहा है, then he should first of all have complete information about the MOA and AOA, since both these documents are public documents. So ये जो भी person company के साथ deal कर रहा है, he should have full information. He should not only read it, he should also understand. वो समझे कि company के क्या AOA में लिखा है, क्या MOA में लिखा है. Then only he should agree to do business with that company. Then only he should agree to be a member of that company. Both these documents are public documents, so they are easily available, and that person dealing with the company should read it first of all and understand it. So doctrine of notice आपको समझ आया that a person dealing with the company must know the contents of the company's AOA and MOA. So there is one case regarding that, that is case of Kotla Venkateswamy versus C. Ramamurthy. So Kotla Venkateswamy versus C. Ramamurthy. So in that case, the articles of the company provided that its deed should be signed by the managing director, secretary, and working director on behalf of the company. सो स्टूडेंट्स, आर्टिकल ऑफ एसोसिएशन में लिखा हुआ था जो भी कंपनी का एग्रीमेंट है वो साइन होना चाहिए मैनेजिंग डायरेक्टर से, सेक्रेटरी से एंड वर्किंग डायरेक्टर ऑन बिहाफ ऑफ द कंपनी. नाउ द plaintiff is a person who is doing the case, accepted the deed of mortgage executed by the secretary and working director only. So जो the person, the other party ने एक agreement करा, but it was signed by the secretary and working director only. Whereas in article of association it was written कि ये जो भी आपका agreement होगा वो sign होना चाहिए किससे, managing director से, secretary से and a working director. Now the other party has signed the deed only by the secretary and working director. तो आप देखोगे तो यहाँ पर managing director ने साइन नहीं करे, it is missing, whereas article of association में लिखा हुआ है कंपनी में that it should be signed by the MD. Now the plaintiff could not claim his deed. जो भी other party है, जो भी case कर रहा है, he cannot go to the court and he cannot claim his deed because it was held that the company was not liable to pay the money under the deed since the deed was not signed by the person as required by the company's article. So students, company के article of association में जब mention था that the deed has to be signed by the managing director, secretary and working director. If there's any signature is missing from the other party's end, then he cannot claim his deed because company is no longer liable because it is his mistake of not reading the article of the company and not following the rules and regulations. So students, this was all about the doctrine of constructive notice. We are just left with two topics, that is doctrine of indoor management and exceptions of exceptions to this doctrine, and we can take this up in the next class. So that's all for today. So now let's see your queries and discuss that. Students, you can post your question and answers in the chat box. ओके, फ्रॉम नेक्स्ट क्लास ऑनवर्ड्स मैं आगे से बायलिंगुअल होंगी, ज़्यादा हिंदी और इंग्लिश दोनों का कॉम्बिनेशन रहेगा जिनको भी प्रॉब्लम हो रही है. प्रीवियस लेक्चर स्टूडेंट्स, अभी आफ्टर सम टाइम दीज वीडियोस विल बी अपलोडेड. ये जो वीडियोस हैं ये अपलोड हो जाएंगी. सो rationale of the doctrine. Okay, I'll repeat it. Please repeat this topic, rationale of the doctrine again. I think your question is not clear. एक बार आप दोबारा बताओ कौन सा टॉपिक समझना चाहते हो. I will send the PDF. I will share the link. मैं बता दूंगी, भेज दूंगी आपको. What is ultra wise borrowing? Students, ultra wise borrowing means जैसे you are doing borrowing, ठीक है, किसी भी third party से, but it is ultra wise. Ultra wise means कि it is against your scope. यू आर नॉट सपोज टू बोरो मनी, बट आप कर रहे हो, जो कोई भी बोरोइंग कर रहे हो, बट इट इज नॉट विद इन द स्कोप ऑफ द बिजनेस। द राइटर कंपनी लॉ के लिए स्टूडेंट्स अनिल कुमार। स्टूडेंट्स आफ्टर द एट द एंड ऑफ दिस चैप्टर, एट द एंड ऑफ दिस चैप्टर आपके लिए इम्पोर्टेंट केसेस हैं। अगर आप देखोगे, एक इम्पोर्टेंट केसेस की लिस्ट है आपके। जब भी चैप्टर एंड होता है तो आप यहाँ से रेफर कर सकते हो। इम्पोर्टेंट केसेस, दैट इज वुड वर्सेस ओडेसा वाटर वर्क्स एक इम्पोर्टेंट केस है। रेफील्ड वर्सेस हैंड्स एक इम्पोर्टेंट केस है। सो जो भी केसेस आपके एंड ऑफ द चैप्टर में गिवन है वो सारे इम्पोर्टेंट है। द टाइप ऑफ क्वेश्चंस दैट विल बी आस्क्ड इन पेपर, स्टूडेंट्स जो पेपर में समझाया जाएगा आपको, जो पेपर में क्वेश्चन जिस टाइप के आएंगे वो हमारी जो लास्ट क्लासेस होंगी, लास्ट 2-3 क्लासेस जो हमारी होंगी आपके एग्जाम से पहले, उसमें मैं आपको डिस्कस करूंगी कि एग्जाम में कैसा पेपर आएगा। अभी के लिए आप फोकस करिए कि कंटेंट क्या है, आपको कॉन्सेप्ट समझ आए। बाइंडिंग अपॉन कंपनी का मतलब है कि अगर कंपनी कोई भी एक्ट्स कर रही है, कंपनी कोई भी ट्रांजैक्शन कर रही है जो अल्ट्रा वायर्स है, मींस बियॉन्ड द स्कोप है, या कोई भी इलीगल एक्ट्स कर रही है, सो इन दैट केस कंपनी भी इक्वली लायबल है। फॉर दैट द मेंबर्स कैन ब्रिंग एन इंजंक्शन। इंजंक्शन का मतलब है कि वो कोर्ट में जा सकते हैं। दे कैन ब्रिंग एन ऑर्डर अगेंस्ट द कंपनी। बाइंडिंग अपॉन कंपनी मीन्स कंपनी इज ऑल्सो इक्वली लायबल, कंपनी भी उतनी ही लायबल है अपने एक्ट्स के लिए जितने की मेंबर्स लायबल हैं। मीनिंग ऑफ ऑल्टरेशन, ऑल्टरेशन का मतलब है चेंजेस करना। आप आर्टिकल ऑफ एसोसिएशन को ऑल्टर कर सकते हो, मतलब उसमें चेंजेस ला सकते हो। मेमोरेंडम, व्हाट इज मेमोरेंडम, मैंने आपको बता दिया। मेमोरेंडम ऑफ एसोसिएशन एक डॉक्यूमेंट का नाम है कंपनी के, जिसको हम बोलते हैं फंडामेंटल डॉक्यूमेंट, जिसमें कंपनी के ऑब्जेक्टिव्स होते हैं, पावर्स होते हैं, स्कोप होते हैं। ठीक है। ऑल्टरेशन ऑफ आर्टिकल में मैंने स्टूडेंट्स ये बताया था कि आप कंपनी का आर्टिकल ऑफ एसोसिएशन को ऑल्टर कर सकते हो, चेंज कर सकते हो। कैसे कर सकते हो? बाय पासिंग अ स्पेशल रेजोल्यूशन। बट उसके लिए कुछ रिस्ट्रिक्शंस बताई थी, समझी थी हमने, जैसे कि आप ऑल्टर कर सकते हो। फर्स्ट ऑफ ऑल आप एक स्पेशल रेजोल्यूशन के थ्रू ऑल्टर कर सकते हो, दैट इज द वन वे ऑफ डूइंग दैट। एंड आप जब ऑल्टर करोगे तो ऐसा नहीं होना चाहिए कि आप कंपनी की पावर्स टेक वापस ले लो, कंपनी की पावर्स टेक अवे कर लो, ऐसा नहीं होना चाहिए। आप ऑल्टर कर रहे हो तो ऐसा नहीं भी होना चाहिए कि आप जो मेंबर्स हैं कंपनी में कि उन पे लाइबिलिटी, उनमें एडिशनल लाइबिलिटी उनकी ऐड कर रहे हो। अगर उनको नहीं पता, या तो उनसे राइटिंग में मेंशन करो कि आप कंपनी के आर्टिकल्स ऑल्टर कर रहे हो एंड वी आर ऑल्टरिंग द लाइबिलिटी ऑफ द मेंबर्स, हम उनकी लाइबिलिटी बढ़ा रहे हैं, तो उनको पता होना चाहिए। तो ये सारे 7, 8, 9 जो हमने पॉइंट्स पढ़े वो रिस्ट्रिक्शंस थी कि आप ऑल्टरेशन तो कर सकते हो, चेंज कर सकते हो आर्टिकल ऑफ एसोसिएशन, बट कुछ रिस्ट्रिक्शंस हैं। इन पर्पसेस के लिए आप ऑल्टर नहीं कर सकते, तो आपको वो रीड आउट करने होंगे। ट्रिब्यूनल मीन्स स्टूडेंट्स कोर्ट। आप कोर्ट बोलो या ट्रिब्यूनल बोलो, इट मीन्स द सेम। स्टूडेंट्स आई कैन नॉट प्रोवाइड माई व्हाट्सएप नंबर, क्योंकि अभी तक ऐसा कोई क्लास का ग्रुप नहीं बना, एंड नोट्स मैंने लास्ट क्लास में भी शेयर करे थे, मैं आपको अभी भी शेयर कर देती हूँ। जस्ट अ मोमेंट स्टूडेंट्स, आई हैव शेयर्ड द लिंक। आप देख लो मैंने पब्लिश कर दिया लिंक, उस लिंक को ओपन करो, यू कैन सेव दिस फाइल ऑन योर डेस्कटॉप। ठीक है स्टूडेंट्स, अब मैं आगे से ध्यान रखूंगी, हिंदी मीडियम के भी स्टूडेंट्स हैं तो नेक्स्ट क्लास से मैं अपना मेथड ऑफ डिलीवरिंग लेक्चर बायलिंगुअल ही रखूंगी, कॉम्बिनेशन हिंदी एंड इंग्लिश बोथ, ताकि आज जो भी प्रॉब्लम आ रही है ज़्यादा इंग्लिश में हो गया है, तो आई कीप दैट इन माइंड। अल्ट्रा वायर्स मैं दोबारा बता देती हूँ। जब भी कोई भी एक्टिविटी हम बिजनेस की करते हैं, बिजनेस में कोई भी ट्रांजैक्शन कंपनी करती है जो कंपनी के स्कोप के अगेंस्ट है, कंपनी के ऑब्जेक्टिव्स के अगेंस्ट है, उसके बाहर जाता है या उसके ऑपोजिट है, जो चीज़ आपके मेमोरेंडम में नहीं लिखी बट आप वैसे कोई भी ट्रांजैक्शन कर रहे हो, आप आपका बिजनेस जो है वो फूड इंडस्ट्री का बिजनेस है, नाउ यू आर डूइंग एनीथिंग दैट इज रिलेटेड टू टोबैको इंडस्ट्री, आपकी कंपनी की जो एक्टिविटीज हैं वो टोबैको मैन्युफैक्चरिंग की है। सो इन दैट केस आपकी जो भी बिजनेस ट्रांजैक्शंस हैं वो कॉन्ट्ररी हैं, वो ऑपोजिट हैं आपके बिजनेस से, तो वो ट्रांजैक्शंस को हम अल्ट्रा वायर्स बोलते हैं, जो कि कंपनी के ऑब्जेक्टिव्स के अगेंस्ट है, ऑपोजिट है। ब्रीच अग्रीमेंट, ब्रीच मतलब कैंसिलेशन। Yes, the company can change its name. हमने हमारे मेमोरेंडम ऑफ एसोसिएशन में पढ़ा था कि नेम क्लॉज है कि उसके अकॉर्डिंग कंपनी अपना नेम चेंज कर सकती है। आई हैव शेयर्ड द पीडीएफ, आप देख लीजिए। मोड ऑफ एग्जामिनेशन स्टूडेंट्स आपको पता लग जाएगा। एज ऑफ नाउ अभी के लिए ओबीई है एज पर द यूनिवर्सिटी गाइडलाइन, बाकी डोंट वरी। मेमोरेंडम ऑफ एसोसिएशन दोबारा से बता देती हूँ। इट इंक्लूड्स द ऑब्जेक्टिव्स एंड द पावर्स ऑफ द कंपनी। इट इज द फंडामेंटल डॉक्यूमेंट, जैसे कहते हैं ना, एक हेड है, एक मेन डॉक्यूमेंट है जिसको हम बोलते हैं एमओए, उसके नीचे एक सब्सिडरी डॉक्यूमेंट है जिसको हम बोलते हैं एओए। सो एमओए में आपकी आती है पावर्स, आपके ऑब्जेक्टिव्स। एओए में आपके आते हैं रूल्स एंड रेगुलेशंस रिलेटेड टू द इंटरनल मैनेजमेंट। Difference between ordinary resolution and special resolution students, ordinary resolution को आप पास कर सकते हो थोड़ी सी मेजोरिटी के साथ, आपको फिक्स नहीं है कि आपको 3/4 मेजोरिटी चाहिए, but for special resolution you need to have 3/4 majority at least to pass that resolution. So special resolution means जिसमें आपको 3/4 majority चाहिए अपने members की, ordinary resolution में आपको थोड़ी सी majority चाहिए। अब ये थोड़ी सी majority means less than 3/4, even if you have 50% then you can also pass that resolution. Binding between members, the articles constitute a contract between each member and the company. The article do not regulate their rights. Such rights can only be enforced by or against the member through the company. So students, इसमें मतलब ये है कि जो भी आर्टिकल ऑफ एसोसिएशन है वो बाइंडिंग बिटवीन मेंबर्स का मतलब है कि कंपनी और मेंबर्स के अगेंस्ट तो चल सकता है, कि अगर इफ मेंबर्स आर नॉट following the articles of association or members are not doing any members are doing anything that is against the company, अगर आप देखते हो कि अगर members आप देखते हो कि members अगर कोई भी एक्ट कर रहे हैं जो इलीगल है, then the company has a right, कंपनी उनको सू कर सकती है, कंपनी उनके अगेंस्ट एक्शन ले सकती है। और जो फर्स्ट पॉइंट था बाइंडिंग अपॉन कंपनी, अगर मेंबर्स देखते हैं कि कंपनी कुछ अगेंस्ट कर रही है, अल्ट्रा वाइज है, तो मेंबर्स इंजंक्शन कर सकती है, ऑर्डर ले सकती है कंपनी के अगेंस्ट, तो ये दोनों एक दूसरे के अगेंस्ट जा सकते हैं, दैट इज पॉसिबल। बट बाइंडिंग बिटवीन मेंबर्स का मतलब है कि मेंबर एंड मेंबर दे बोथ कैन नॉट गो अगेंस्ट ईच अदर। कंपनी और मेंबर्स तो एक दूसरे के अगेंस्ट हो सकता है, बट मेंबर्स एंड मेंबर्स दे बोथ कैन नॉट इन्वॉल्व इन्वॉल्व द कोर्ट फॉर दिस पर्पस। अगर एक मेंबर को दूसरे डायरेक्टर से कोई इशू है या दोनों के दे बोथ आर नॉट agreeing with each other, तो for that they cannot go to the court, इसमें कोर्ट की इन्वॉल्वमेंट नहीं है। लास्ट टॉपिक मैंने बताया था आपको, डॉक्ट्रिन ऑफ कंस्ट्रक्टिव नोटिस। इसका मतलब है कि जो हमारे मेंबर्स हैं और एनीथिंग जो भी कंपनी के साथ डील कर रहा है, दे शुड अंडरस्टैंड, नॉट ओनली दे शुड नॉट ओनली नो अबाउट इट, दे शुड अंडरस्टैंड, उनको समझ आना चाहिए कि जो भी कंपनी के साथ डील कर रहा है कि कंपनी के एमओए और कंपनी के एओए में क्या लिखा है, उनको बहुत अच्छे से समझ आना चाहिए कि मेमोरेंडम ऑफ एसोसिएशन एंड आर्टिकल ऑफ एसोसिएशन का क्या मतलब है, ठीक है, बिफोर डीलिंग विद द कंपनी। नो, पार्टनरशिप डज नॉट हैव एमओए एंड एओए, ये सिर्फ कंपनीज के होता है, पार्टनरशिप डज नॉट हैव दिस। पार्टनरशिप के लिए पार्टनरशिप कंपनीज हैव देयर ओन पार्टनरशिप एग्रीमेंट, उनकी अपनी पार्टनरशिप डीड होती है। आप इस तरह के स्टडी मटेरियल को भी रेफर कर सकते हैं, दैट इज अप टू यू, आपको जो भी बुक इजी लगती है, कंफर्टेबल लगती है। Book is Anil Kumar, as always. Relationship between MOA and AOA, I have told already कि AOA आपका एक सेकेंडरी है, सबऑर्डिनेट डॉक्यूमेंट है, MOA हायर डॉक्यूमेंट है। आप अगर कोई भी एक्टिविटीज एमओए के प्रोविजन से बाहर जाओगे, कोई भी एक्ट करोगे, तो वो वॉइड है, वैलिड नहीं है। बट अगर आप एओए के अगेंस्ट कोई प्रोविजन करोगे तो वो वैलिड भी हो सकती हैं विद द अग्रीमेंट ऑफ शेयर होल्डर्स। देर आर 13 चैप्टर्स इन द कंपनी लॉ बुक। अनिल कुमार। सब्सिडरी मीन्स सेकेंडरी, जैसे हम कहते हैं ना, एक प्राइमरी, सेकेंडरी, होल्डिंग, सब्सिडरी। होल्डिंग मीन्स प्राइमरी, मेन, जो आपका हेड होता है। सब्सिडरी मीन्स उसके जो अंडर आते हैं। सिमिलरली एमओए एक होल्डिंग है, एक हेड है, उसके अंडर जो आते हैं, एनीथिंग दैट इज समथिंग दैट इज कंट्रोल्ड बाय द होल्डिंग कंपनी। जैसे आप कह लो कि जो एओए है वो एमओए के अंडर आता है, तो उसको हम सब्सिडरी बोलते हैं। So I think I have answered most of your queries, and I have already मैंने आपको link share कर दिया है, and from next class I'll try to keep it bilingual. मैं इसको bilingual रखूंगी, आपको हिंदी में भी अच्छे से explain करूंगी और इंग्लिश में भी अच्छे से explain करूंगी। And thank you for your feedback, and we will continue with the last topic. हम जो हमारा जो भी last topic रह गया है, doctrine of indoor management, उससे start करेंगे। And we will start the next chapter, chapter number 6, in the next class. Students, हमारे पास total 13 classes हैं till 10 December. So my strategy for teaching you guys is that I'll take upon every chapter in every class. So don't miss any class. आपका सिर्फ 17th को दिसंबर को I think you have your exam, आपका कंपनी लॉ का पेपर है as per the date sheet. So मेरी स्ट्रैटेजी ये रहेगी कि मैं हर क्लास में एक नया चैप्टर आपको स्टार्ट करवा दूं, बिकॉज अनिल कुमार बुक के अकॉर्डिंग यू हैव 13 चैप्टर्स. सो don't miss any class, just a 1 hour class. So don't miss it. See you in the next class and all the best. Thank you so much.